If you're a law student trying to get your head around fundamental rights, the right of assembly in Hong Kong is a huge one. It's complex, it's constantly evolving, and today we're going to break it all down for you. And you really can't understand this topic without starting right here, with how Hong Kong's top court thinks about it. This quote, it's not just flowery language. The Court of Final Appeal is sending a clear message. The right to assemble isn't just some nice-to-have privilege. It's a core building block of a democratic society, right up there with freedom of speech. So, to get through this, we're going to tackle it in 5 chunks. We'll kick off with the constitutional foundation, then look at the regulatory system itself. After that, we'll unpack the all-important proportionality test, see how it worked with the anti-mask law, and then wrap up with where things stand today and what you absolutely need to know for your exams.
All right, first things first, where does this right actually live in the law? Let's dig into the constitutional bedrock.
You'll find it locked in place in 2 of Hong Kong's most powerful legal documents, the Basic Law and the Bill of Rights Ordinance, or BORO. Now, because they basically say the same thing, the courts call this a parallel right. And why does that matter? Well, it's a big deal because it means any attempt to limit this right has to meet these super strict standards set out in the BORO, which comes straight from international human rights law.
Okay, so we've established this is a fundamental right. But it's not a free-for-all, right? So how is it actually managed on the ground? Let's check out the system. This spectrum is a great way to see how different places handle this. You've got some countries where you just protest and only a court can stop you. On the other end, you need to get a permit first. Hong Kong lands right in the middle with what we call a notification plus executive discretion system. What that means is you have to tell the police you're planning something, but then the police, an executive body, gets to decide if it can go ahead or what rules you have to follow. The rulebook for all this is the Public Order Ordinance, or the POO, and here's the absolute key. Under the POO, if you don't tell the police about your public meeting or march and it's over a certain size, it's not just a slap on the wrist, it instantly becomes an unauthorized assembly, and that is a criminal offense. So you've got this clash, right? On one hand, a fundamental right. On the other, the police having the power to restrict it. How in the world do the courts find a balance in that tension? Well, the answer, the big one, came from that same landmark case from 2005 we mentioned earlier, CUHK. This case went straight at the heart of the POO, challenging whether the police had too much power. And what the court did here was actually pretty clever. They looked at the law, which said the police commissioner could ban a protest for public order, but it included this really broad French term, ordre public. The court said, whoa, that's way too vague. It gives the police a blank check. So they took a legal scalpel and just cut that term out of the law. And then, and this is the crucial part, they laid down a new rule. From now on, the police can't just do whatever they want. They must apply the proportionality test before restricting any assembly. Their power was now limited by law. But it wasn't a clean sweep. You have to check out Justice Bahari's powerful dissent. He basically said, hang on a second, a decision this huge to ban a protest, shouldn't that be made by a judge with all the safeguards of a courtroom, not by a police chief? And his view is actually the more common one you see in other places, like Germany, where only a court has that kind of power. So, we have our legal tool, the proportionality test. Now let's see how it holds up when things get really heated. And there's no better example than the recent anti-mask law. Okay, let's fast forward to 2019. The city is seeing massive and sometimes violent protests. In response, the government uses emergency powers to ban face coverings at public assemblies. Almost immediately, that ban was challenged in court as being unconstitutional. So pay attention, because for your exams, this 4-step test from the CUHK case is pure gold. Step 1. Was there a legitimate aim? The court said, yep, preventing violence. Step 2. Was there a rational connection? Again, yes, the court figured masks could make people bolder and harder to identify. Step 3. Was it no more than necessary? This was a big one. The court decided it was, arguing that preventing violence was key and that, wearing a mask isn't the core purpose of protesting. And finally, step 4. Did it strike a fair balance? The court concluded that the public good of stopping violence was more important than what it called a limited hit to individual rights. And with that, the law was upheld. But this is where the debate really heats up. The court literally said that wearing a mask does not lie at the heart of the right to peaceful assembly. But critics immediately pushed back, asking, is that really true? In a world where people might be scared of getting fired, or worse, for showing up to a protest, Isn't anonymity essential to being able to exercise that right at all? It really boils down to whether you see anonymity as an optional extra or as a vital shield for privacy and free expression. So let's pull all these threads together. What does the right of assembly look like today, and what are the absolute essentials you need to cram for your exams? Well, the ground has definitely kept shifting since 2019. The few protests that do get approved have come with brand new rules, like requiring people to wear numbered tags around their necks. And at the same time, we've seen arrests under new security laws for things like social media posts that were deemed seditious. And that brings us to another case that really changed the game, Lo Kin Man in 2021. Here, the top court hugely expanded what it means to take part in an unlawful assembly. It's not just about being physically on the street anymore. The court said that anything from helping out behind the scenes to just encouraging people online could be enough to get you convicted. Okay, revision time. If you remember nothing else, remember these 5 things. 1. The right is protected by both the Basic Law and Borough. 2. The system is run by the CUHK, which is a notification plus discretion model. 3. The CUHK case put the proportionality test in place to limit police power. 4. The CUHK hand case is your go-to for how to apply that 4-step test. And 5. Lo Kin Man blew the doors open on what taking part means, including online activity. Got it? Good. Which leaves us with one last big question to chew on. The law on the books, from CUHK, is still a notification system. But when you add up all the changes, the new conditions, the huge definition of taking part, the new security laws, what's the reality on the ground? Has Hong Kong's system, in practice, started to look a lot more like a system where you need to get permission first? That's something for you to think about.